The courtroom is already tense, and Judge Boyd wastes no time cutting straight into the matter. But notice how quickly confusion creeps in. Duplicate case numbers, clerical errors, a moment of hesitation. This might look like paperwork drama, but don't underestimate it. In a courtroom one, clerical slip can delay justice by weeks, even months. Here's the first lesson. The law isn't just about justice. It's also about precision. A missing file, a wrong case number, and suddenly accused individual could walk free, at least temporarily. Do you think that's fair? Should bureaucracy hold that much power in the balance of someone's freedom?
All right, and the new number one, who's alleged in the new number one?
And there is a no contest order.
Okay. And what's the aunt's name?
Christina Maria Rodriguez. Yeah.
What's the last name?
Rodriguez.
Rodriguez.
Rodriguez. Yes.
And the middle name?
Maria.
All right, we're going to go on the record.
Sorry.
Court is calling 2025 CR 003315 and 2025 CR 00. Wait a minute. Just one second. I'm so sorry. I have two of the same. She only has one case with the court, correct?
That's correct. I brought my own. Both in this order.
No, there should be two. The one that you bond and then the new number one, which I believe. Oh, well, it's not assigned to this court. Yeah, you're right. Just the one.
Okay. All right. So we can. Let's one second. Okay. I see now. All right. Court is calling 2025 CR 003315 State versus Melinda Juanita Gonzalez. Could I have parties announced?
Rick Pena for the state of Texas.
Probably just classes.
And are you Melinda Juanita Gonzalez?
Yes, Your Honor.
All right. You're here. You have a motion to enter adjudication of guilt and revoke community supervision. You're entitled to a bond. The only question for the court to consider is the bond amount. And defense, you said you've reached an agreement with the state of a bond of $30,000?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Melinda Juanita Gonzalez.
All right. Have you ever had any type of mental health diagnosis in the past?
No, Your Honor.
Have you ever been on any type of medication for any mental health issues?
No, Your Honor.
All right. Have you ever used any type of controlled substance or illegal drugs in the past?
No, Your Honor.
And states you're in agreement to a bond of $30,000?
Yes, Your Honor.
A $30,000 bond. That's not just a number. It's a financial wall. For many defendants, it's the difference between sleeping at home or in a cell while awaiting trial. Judge Boyd also attaches 30 sober meetings in 30 days. That's one meeting every single day. A grueling demand. Here's where law and humanity clash. Is this accountability, or is it pressure designed to break someone? Imagine holding down a job, paying your bills, caring for kids, and also attending daily mandated meetings. Is this true rehabilitation, or just punishment wrapped in paperwork? Tell me in the comments what you think.
All right. The court is going to set your bond at $30,000. There's to be no contact with Christina Maria Rodriguez. And based on the alleged offense out of county court at law number 1, there's going to be 30 sober meetings in 30 days. And there's to be regular UAs, waive fees. Is there anything else?
No, but if those matters are already being done in county court number one of the EWI, they will serve.
Yes. All right, Ms. Ferguson, I need a jury, we're off the record. I need a reset for a MTR. You can set it as a contested.
Yes, September 15th.
All right, if you'll give her a reset form for September 15th, and that will be contested. If it turns out it's not contested, please let probation know the day before.
Excuse me.
Yes. Hello. Hi. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God. All right, you can lower your hand. Do you need to take a breath? Okay. Just let me know when you're ready to proceed, okay? Yes.
Dolores, if you would, ma'am, just take your time and speak into the microphone, state your full name for the record.
Dolores Brown.
Just a little louder.
Dolores Brown.
Can you tell us how you're related to Frankie Law?
He's my brother.
And would you describe your relationship with Frankie?
Yes, we've always been close. Growing up, we've had fights. My mom always told us that to make sure we take care of one another because we're all we have. And just love him so much. I have handled this situation that has occurred. It's very hard and difficult on a family, including my dad. We just lost my mother right before the incident happened. And that's why it's just difficult for me to stand this. My dad is deteriorating, and if anything, my brother does go to prison. He's I know it's not gonna make it. It takes too many medications. It's hard for me. It's hard.
You've done good. Let me just ask you a couple of questions. Just step back just a little bit. Okay, and just speak loud enough. Microphone here. You've certainly come to court every time we've been to court. Is that correct?
Yes, sir.
You understand exactly why we're in front of Judge Ford this morning.
Yes, sir.
She's got to make a determination whether to give Frankie prison time. There's a range in that we've limited, and there's certainly an application for supervision. Where I'd like to ask you if you could just, you've known obviously your brother and sister, but could you tell us, the judge, some of the good qualities of Frankie that would make him a good candidate for probation?
Well, he's always protecting me, and he was with me. A lot of times he was better to me than my siblings. And all I can tell you, Your Honor, he regrets everything that he's done.
Frankie's sister takes the stand, her voice breaking as she defends her brother. Here's the legal strategy. Defense attorneys often lean on family testimony to paint the defendant as more than the crime. A son, a sibling, a caretaker. But there's a deeper tension here. Is love clouding judgment? Her words about family shame and remorse are powerful. But judges know remorse is easy to say, harder to prove. What would you do in her place? Could you stand by your sibling if their actions brought shame to your family? This is where morality collides with loyalty.
Put shame on the family. Bringing shame to my dad, especially after just losing my mother.
Let me ask you, if he's granted probation, does he have the continued support of your family?
Yes, It absolutely, Your Honor.
You in Frankie's life every day?
And ever since this incident has been, Your Honor, and with his medical condition, I've been checking on him more, been making more contact, just trying to ease his mind, to let him know that, we don't make mistakes and, and we don't make mistakes and you have to own up to your responsibility and he does show the remorse for what he's done and the shame that he brought on his wife,
And if he is granted probation, will you remain in his life in a supportive capacity?
Your Honor, if you were to,
Go ahead.
if you were to grant him probation, I stand here as a woman and I can guarantee that nothing like this will happen again. And if you can attach me to any type of documentation, because I'm not going to pressure the court, and I can guarantee that this will never happen again or anything else going forward. Thank you.
Go ahead.
And I'm seeing and I'm scared of you myself, and what you do.
All right, so this is what I want you to know, and all of the witnesses who testify. Because people always are concerned, did I say the right thing? Did I say too much? Did I not say enough? But I want to let you know that you're giving me insight into your brother. I want you to know that there's nothing that any witnesses that have come before me that have said anything that has hurt him, all right?
Thank you, Judge.
All right, do you have any questions?
No question.
All right, thank you.
Judge, lastly, Mr. Lott has a brother, Eddie McAfee, who I've shared, he submitted a letter. I shared it with the state. I'd like to share it with the court right now.
Okay.
In support of his application for probation.
Hello,
No, good morning.
good morning.
Okay.
So, Miss Abrams, where are we?
So Judge, Miss Holmes is doing fairly well. She reports to have obtained employment, which begins on the 23rd or 25th. 25th. She has enrolled in her anger management class, which begins on the 23rd. She's found temporary housing with a friend. She is trying to get into her own place, and we'll talk about that in a little bit further. Her children start school here soon. There is some issue with one of the children. We don't know if she's already fully enrolled because of the GPS requirements. So I'm going to ask for something with the GPS. He's been making her probation meetings. She reports to not have had any contact with whom she's not supposed to have contact with, nor the address. She seems in much better spirits today than what we've seen in the past.
All right, so how old are your children?
16 and 18.
All right, and so which issue with the school with regards to GPS?
16. It's on a different side of town.
All right.
And so she needs to make sure that she's fully enrolled into school.
Okay. So what do we need to do?
So, Judge, at this point, we're asking that the GPS, she's not had any compliance issues with the GPS, and we're asking if the GPS can be changed to tracking only.
Any objection?
No.
All right, so then it will be GPS tracking.
I did tell her that if you order GPS tracking only, Judge, that to make sure she still does not go where she's not supposed to go. And she understood that.
Okay. All right, is there anything else?
Not at this point, Judge. Do you, Ms. Holmes, do you have anything, any
Um,
concerns or anything?
No, not really no major concerns. I just want to be able to go look for a placement in the children. That's it.
All right. So do you need help with finding housing?
That would be great. And also just being able to go out and go put in the applications because I asked GPS and they're telling me that it's not approved. I have to ask
Well,
for.
here's the thing, that issue's already been solved. You'll be on GPS tracking, but with regards to GPS tracking, you are not, are you chewing gum?
Yes,
Mm-mm,
sorry.
that's okay. All right, so with GPS tracking, you're allowed to move freely about the city, except no contact with the complainant, no contact with the address, don't go on that street. You understand? Because GPS tracking will show your routes and where you're going. So you see, you're able to see if they can do something with housing as far as give her different resources where she can go.
Give her the information for the reentry center, Ms. Sandoval, see if they can provide any help.
All right, so they will do that. Is there anything else?
No, Judge?
State anything you.
No.
All right, state you may be excused. All right. Yeah, they don't understand how loud that is, and I can't hear when they're running paper. Anything else you need from the court? All right. So do we need to do another status update with her?
Judge, if we do that status update, because she just secured that job, I would ask that it's either on a Tuesday or Wednesday, and if we can do it via Zoom, that would be great.
All right, so we'll do a status update date by Zoom. And I know usually with employments, they put you on a probationary period. So-
That's why I asked for a Tuesday or Wednesday, because I think those are the days she's gonna be off.
All right, so Norma, if you can give me a reset on this in 60 days on a Tuesday or Tuesday, okay.
Stick with our rules.
All right. I feel like I need to go pick up my baby. Call somebody who has a private plane, go pick her up.
She's fine.
You need cameras.
They're gonna figure out.
It's at 3. That's insane.
It's fine.
No.
She probably gonna like it.
Yeah, okay, I'm gonna go with that. She's gonna enjoy it too much.
There you go.
October 7th, Judge.
All right, October 7th, once you sign the reset form, you're excused. Make sure you stay in contact with your probation. If there's some issues, let probation know. If you feel like they're not addressing it, you can come back to the court. All right, thank you.
Judge, currently Ms. Holmes is reporting 2 times a month with her officer. Do you want that to remain, or do you want to switch that to once a month?
What are your thoughts?
That's.
No, you didn't have it.
I tell you what, we can keep as is, and when Ms. Holmes, if you come back in October and there are no complaints, we can do once a month. All right, Frankie Lott. Good morning.
Morning, Judge.
Good morning.
Remember me?
Yes, I do. All right, court is calling 2025 CR 001604 State versus Frankie Lott. Could I have parties announced for the record for the state?
Grant Crespo for the state, Your Honor.
Patrick Hancock for Mr. Lott.
And are you Mr. Lott?
Yes.
All right, you entered a plea of guilty on July 18th.
Yes.
According to your plea bargain, and you entered a plea of guilty to counts 1 and counts 3. According to your plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $4,000 fine. The state opposes your application, and there's to be Chapter 62 compliance.
This moment cuts like a blade. Judge Boyd zeroes in on the contradiction. Frankie claims debilitating medical conditions, has arthritis, chronic pain. Yet he still managed to drive and arrange to meet someone he believed was a minor. This isn't just cross-examination. It's surgical. Boyd exposes the heart of the case. If you're sick enough to need compassion, how were you healthy enough to commit the crime? That's not a question of law. It's a question of credibility. And in court, credibility can outweigh tears, pleas, even medical charts. Did Frankie just undercut his own defense?
Have both parties had a chance to review the PSI?
Yes, Your Honor.
Yes, Your Honor.
Any objections?
Judge, there's no objection to the PSI, but I think Mr. Lott, I know the court's familiar with his medical background. He's had a couple of seizures in the courtroom, so he gets nervous. He's asked me to communicate to the court that he would like to retract his statement to his PSI officer, where when asking about the instant offense, he made an excuse for his behavior. He accepts responsibility for his behavior. I know that because prior to the PSI, he and I have had that discussion. I think he gets nervous in settings, and I think it's the answer he gave is a reaction towards self-preservation with his family and his friends, and he's just very ashamed of his behavior. So I think the best we can say today, Judge, is regretfully, we don't want you to think he's making excuses, because that's certainly the way it reads. He's here today to take full responsibility. His sister and his wife were present to testify on his behalf. He's just struggled with the shame and humiliation this has brought to his family.
All right. Any witnesses?
Yes, Your Honor. The first witness I have is Cecilia Jenkins Lott, his wife.
All right. All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record.
My name is Cecilia Jenkins Lott.
All right. And if you may proceed.
Yeah, proceed. Ms. Lott, good morning. Thank you for coming down. You understand we're here today for the sentencing of Frankie Lott. Is that correct?
That's correct.
Would you explain your relationship to the judge of Frankie Lott?
I'm his wife. We've been married for 4 years.
And can you tell the judge how long you've known Mr. Lott prior to being married? How long you dated him?
We dated for 10 years prior to our marriage.
Did you grow up here in Bexar County?
No, I'm originally from Detroit. I've lived in San Antonio since 1984.
And can you tell the judge what your work background is, Cecilia?
I've been in the legal system working with attorneys since I was at age 18. I worked in litigation for over 30 years, and I've been in real estate for over 10 years.
And you're currently working in a law firm, is that correct?
Yes, I work at a real estate law firm.
Ms. Lott, can you give the judge some background? I know it's very long, but just kind of an overview of Frankie's medical conditions as he stands here today.
He was diagnosed with MS about 3 months after we got married in 2021. He's since subsequently been diagnosed with rheumatoid arthritis. He used to get shocks in his back and his neck because his lumbar and his cervical disc are degenerative.
And is he currently under medical care and medication?
He hasn't seen his general physician in 1.5 years since he lost his insurance. He sees a psychiatrist every week, sometimes twice a week, because they'll see an intern and a doctor. He is currently on medication. The psychiatrist just added a third, an antipsychotic, He's on depression medicine. He has patches for his pains in his back.
And prior to his arrest, Cecilia, can you tell the judge about his work background?
He actually worked for the Criminal Justice Center. He worked there for a few years, leading up till January of 2024.
And you are certainly familiar with the charge that he's pled guilty to 2 counts to this court. Is that correct?
That's correct.
And you're not here today to make any excuses about that?
Oh, no, I think he did something stupid.
And has he indicated that to you?
Yes, and he's apologized profusely, and he just thinks he did something stupid.
You are aware that, I guess prior to this arrest, he really has no criminal history to speak of.
No,
He's been on bond for an extended period of time, is that correct?
yes, since January of 2024.
Has he been on home arrest, is that?
Yes, that is true.
And has he abided by all the conditions of his plea?
Oh, yes, I am the warden.
So you know that one of the decisions that we have agreed to leave up to the judge is whether she would give Frankie time in prison or a shot at community supervision. Do you think he's a good candidate for probation?
Oh, yes,
And can you tell the judge in your own words why he's a good candidate for probation?
because he repents for what he did, and he has health issues that would make it impossible. He has health issues. He has repented. I believe that he would be okay at home. I've changed the phones. He's not allowed to have text messages or anything on his phone. I'm there. I monitor. I control the phone. I turn it off at night at that time. And he's homebound. He only leaves to go to his doctor's visits or to pick up prescriptions. And he's not allowed to do anything but be at home.
And obviously, I think your statements include that you would be supportive of him if he were placed on community supervision.
Oh, yes.
Is there anything else that you would like to tell the judge, Cecilia, that you would like her to take into consideration in making a decision about whether to give him probation or prison time?
He's actually a good guy. He was brought up to protect everyone. He's the oldest, so he looks after his brother and sister. He pseudo-adopted my adult daughter, who thinks he runs the world. He's a good guy. He just doesn't always think things through, and he sometimes does things that are stupid.
All right, well, that's succinctly put. Thank you very much, and Your Honor, I'll pass the witness.
Thank you.
Ms. you have any questions?
Just a few questions for you. Good morning. I just have a few questions for you, okay? You said that he was working in the criminal justice system up until January of 2024, correct?
Yes.
And in January of 2024 is right when he committed this criminal offense?
Right, and that's why he lost his job.
And I know I'm grateful for it, and you say, you control his phone and you control everything he does, but can you tell me in this report what he's done himself to take accountability for his actions? Because I appreciate it, but he is a grown adult as well, right? So he should be able to control his urges and his actions. So what have you seen him since leading to this case do in that regard?
What do you mean, like
Just make sure she can hear you.
outside of the home?
Or just
Well, he's very apologetic. He can't do anything or go anywhere. So, I mean, he knows that, and he feels bad for what he did and how it's affecting the entire family.
okay, no further questions for this witness, Your Honor.
May she be excused, Your Honor?
Yes. Thank you so much for coming to talk to me about it.
Dolores Locke Brown.
All right, so we're here, no gum chewing. Okay, all right. So we're here for discovery because you were recently appointed.
Correct, Judge.
So where are we on discovery?
I believe I've got discovery that the DA has uploaded. However, Mr. Prince is informing me of several places that I believe need to get some medical records that he is requesting me to get. I may need to file, I believe I do need to file to do it the proper way. An investigator to go get those records for me as opposed to me to get them under the business records affidavit. So we need to do in the proper method that we may need to enter them. So that's where I am with that information, Judge. But I believe the VA has provided through the e-discovery, I believe they've uploaded the things that they have.
All right, Ms. Ferguson. On this case, this is your final discovery date. If I can have 45 days and Mr. Prince, court starts at 9 a.m. Why were you late?
I was in another courtroom.
Yeah.
This is
All right, so here's the thing. Now you know where your courtroom is, so make sure you're here, okay? But your attorney did tell me you were in another courtroom, so you're in the 187th, okay?
And Your Honor, I will be e-filing the appropriate motion to get the appropriate discovery help. I'll put it
All
that way.
right. All right, what date?
September 25th.
All right, September 25th, that's your final discovery date. Once you sign the reset form, you're excused, and thank you for dressing appropriately for court. All right, just have a seat and your attorney will bring the paperwork to you to sign. Thank you.
Thank you, Judge.
Thank you. All right, Troy Xavier Trevino.
Morning, Judge.
Good morning. All right, today's plea deadline date.
Yes, Your Honor. I think it was either late Thursday or Friday afternoon. We got a new discovery bulletin of about 100+ jail calls. And so we're hoping we can extend that deadline a little bit.
All right, are these jail calls that your clients alleged to have been made? All right, so today, you should know what's on your jail calls. Today is the plea deadline date. So either you admitted something in the jail calls or you didn't. I would always tell my clients, when you make a phone call from the jail, they give you fair warning that everything is going to be recorded. Then people get in the middle of their conversation and they just start talking about everything. So today is your plea deadline date. You know what's on the jail calls because you made them. So either you're accepting a plea or you're not. If you're not, then the next date you're getting is a jury trial date, and the court will not accept any plea bargain agreements in this case without good cause. So, jury trial?
Well, you'd allow me to talk to him some more, Judge.
Yes.
I appreciate it.
All right, thank you. All right, who's here on Ruben Renteria?
Morning, Your Honor.
Good morning. All right. So he has a motion to revoke, and he has a new case. Well, two new cases. So where are we?
So Judge, we filed a motion for legislative continuance. I'm actually gathering back in today at 1 o'clock. But I've also confirmed with the state, Mr. Renteria has been in custody since April 21st to try and get bond set on the MTR to deferred adjudication. The state has agreed to a $40,000 bond on that, and then they're entering an offer. There's a case out of County Court 12 that I'm going down to talk to them to see if we can get everything.
Okay, so has a motion for a bond
Yes, Judge.
been set?
Been filed, yes, Judge.
All right, can you pull the motion request for bond on 2024 CR 2438? All right, court is calling 2024 CR 2438 State versus Ruben Renteria. Can I have parties announced?
Jason Gary here for the state, Your Honor.
Mark with defense.
And are you Ruben Renteria?
Yes, sir.
All right. In this case, you are on deferred adjudication, so you're entitled to a bond. And my understanding that you all have reached an agreement on the bond?
Yes, Your Honor.
And what is that for?
$40,000.
Is that correct, State?
Yes, it is, Your Honor.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Ruben Renteria.
All right. Have you had any mental health treatment in the past?
Uh-uh. No.
That's either yes or no.
No, Your Honor.
Have you ever received any type of medications for any mental health issues?
No, Your Honor.
Have you ever used any type of drugs in the past?
Judge, I would object to the fine questioning.
All right, so here's the thing. I have to set conditions for his bond. And in order to set conditions for his bond, I need to have him then do a data sheet on any type of drug history, because otherwise I could send him out into this world. He needs drug treatment and I can't give it to him because I don't know if he needs it or not. So if you're objecting to the question, then I won't ask the question.
Oh, Judge, I mean, if the court will direct their attention to his record, he has multiple charges for drug possession. But asking him to make an admission on a pending MTR with new number one cases, I would have.
I just said in the past, but I'll note your objection. All right, this is what the court is going to do. The court is going to set your bond at $60,000. There's going to be full GPS, waive fees. Ms. Ferguson, if you could confer with Ms. Ferguson and they'll give you a contested hearing date. All right. And on the other cases, counsel, do you have all discovery?
I believe we do, Your Honor.
All right. So Ms. Ferguson, if you'll give them a contested date and if y'all confer with Ms. Ferguson and she'll get a date to you.
Thank you very much.
You're welcome.
Our judgment's not been called for under that case.
There was no bond. All right. Thank you.
Thank you, Judge.
You're welcome.
Judge, if I could just speak to the PSI and on the plea bargain, if I may, if it's time.
Yes. Well, State, you've heard testimony. Does your plea bargain still remain the same?
Yes, Your Honor.
All right. Yes, I'll hear you.
Judge, I think we've been to court numerous times, and I think the court can remember some of the health struggles that Mr. Lott has had. And I think the probation office did a good job of documenting his medical history from.
And just here's my question with regards to the medical history. Is this something that's brand new, or were these medical issues, a part of these medical issues, a part of when this incident occurred?
I think his MS symptoms started in COVID, although he was able to work through it, but I think his work was limited. Certainly his arthritis and back issues have outdate the origin of this case. So
he's had these conditions prior to the commission of this offense?
Yes, ma'am. Okay.
All right, you may proceed.
And so, Judge, I think the court's aware of it. Obviously, we've put a date on it now. I can't tell you how long before the commission of the offense, but certainly the toll that it's taken on him has been significant. But, you know, he stands here today, Judge, as a 57-year-old man. I think there was one hiccup that I was reminded of reading in the PSI today, some selling alcohol to a minor when he worked in a restaurant, I guess, back in 2002. I hope the court won't hold that against him. I think other than that, he's lived his life being a good man, making good decisions, and certainly being a productive member of our community. And then he makes this mistake, Judge. It's a whopper. We get that.
All right, so here's my question. And counsel, maybe you can address this. Maybe you want your client to address this. So there's an online solicitation of a minor. And I am completely, I'm going to disregard the fact you want me to disregard, where he says that basically he was tricked. And I understand with online, I represented people before. I understand with online solicitation of a minor, you are sort of tricked in the fact that you think you're talking to a minor and you're not talking to a minor. So I understand the trickery in that portion, but this is what I want to address. So he's having this conversation with someone he believes to be a minor, and then he agrees to meet up with the minor. And he has all these medical conditions. No, that's what it says in the stipulation, that you actually agreed to meet up with the minor, and they arrested you, I believe, at the meet.
They arrested him on the scene where the undercover cop and Mr. Lott agreed to meet.
So he has medical issues. He has the MS, as you're saying. arthritis, all of these chronic issues, but he is holding a conversation with someone he thinks is a minor, and then he goes to meet up with a minor with all these conditions.
Well, Judge, if you're asking us to make an excuse to him,
No, I mean, I'm just,
guilty to it.
no, I understand he's pled guilty, but I'm trying to figure out the status of his medical issues.
Well, Judge, I don't know whether he was, you're asking me if you felt okay to meet up that day or what the situation is. I can tell you that he's not feigning his medical issues.
Oh, no, I believe his medical issues are real, based upon the PSI and based upon issues that he's had when he's in the courtroom. I'm just trying to look at him globally so that I can make an appropriate decision on punishment in this case.
Well, I don't know exactly what the court's looking for. I certainly think he had medical issues that day, at that time during his life. Now, whether he felt okay to get into a car and go to a meeting, sounds like he did. So, but I can tell you that was how long ago? A year and a half ago, or some months ago. So I can tell you from his family and talking to him, his medical condition has deteriorated. So, and I think that's obvious to everybody. So hope that answers your question.
Yes, and that's what I want to, for you to elaborate on that part.
Yeah. So, it has, Judge, I think you've seen it. I think these ladies, to the best of their ability, have articulated that. As his wife said, he's homebound. Mm-hmm. He has nowhere to go. She's in charge of his phone. He's not going anywhere. He's lost his insurance. So, he's at the mercy of the state. I think that if he were not taking this serious, then he would have violated the conditions of his bond, and it would have been a nuisance to the court a long time ago. So, this mistake happens. He was afraid of losing his family. He's been able to maintain a relationship with his family, except time doesn't do anything with him except make his health worse. So I think medically, Judge, he's a good candidate for probation. I think, quite frankly, if he would go into the system, he's a burden to the system. That's not making an excuse for his behavior. But if the court wants to look at this situation globally, he's got a support group. He's going to have to register as a sex offender. His health is deteriorating. It's not going to get better. He has his wife lives at home with him. His sister's in his life every day. Brother, from this letter, has asked the court to not lose sight of one bad decision in a man's life, but perhaps to punish him for his goodness as well, because he's not a man with a criminal history, no drug or alcohol problem. I think it was a mistake that the court has seen a lot of men make. He made it, and as his family and the very strong women in his life have stated, they don't expect that he'll make another mistake. They just want the opportunity to care for him in these years of need and take care of him. And that's all we can offer the court.
All right, State.
The state, just looking at the PSI, Your Honor, our concern is, I know that they've retracted today what was on the PSI, but our concern is the same as what he told the cops to what he said here, is that his goal was to go find this child and tell her she shouldn't be doing this, and that, trying to find who her parents were so that he could tell them. And the state's concern is that he wasn't taking accountability then. He wasn't taking accountability when he did the PSI, only today when he's coming forward to the court, Your Honor. And that the excuses for the types of conversations that he was having with what he believed to be a 14-year-old girl on the internet, and then proceeding to meet up with that individual that he believed was a 14-year-old minor. That's just the state's concern, Your Honor. He had these health conditions. While they may have deteriorated, he had them. He drove a car. He went to meet this individual, Your Honor, and that's pretty much all the state has, Your Honor.
All right.
Here it is. The hammer drops. Judge Boyd delivers a nuanced ruling. 2 years concurrent, not the maximum, but with sex offender registration. It's mercy and punishment in one. She even says, a sentence shouldn't be a death sentence unless it's the death penalty. That's more than legal commentary. That's philosophy from the bench. In the end, Frankie's health spared him from a longer sentence. But it didn't erase the crime. And here's the takeaway. Justice isn't just about what you did. It's about who you are, what you can handle and what society demands. If this stunned you like it did me, smash that like button. Drop your verdict in the comments and subscribe for more courtroom breakdowns every week.
All right, this is what the court is going to do. And the court is taking in consideration your lack of history. The court is taking in consideration your medical conditions. The court doesn't believe a sentence should be a death sentence unless it's called for the death penalty. And I say that if somebody is receiving the death penalty, all the other sentences, they're not supposed to be a death sentence. So I'm taking all of that in consideration. I'm taking your health in consideration. The court is going to find you guilty of counts 2 and counts 3. Counts 2 and counts 3 will run concurrently. There should be Chapter 62 registration, and the court will sentence you to 2 years in each cause number. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you. You're welcome. Who's here on Alexander Roca? All right. Court is calling 2025 CR 005777, State versus Alexander Roca. Can I have parties announced for the record?
Megan Galloway from State.
Alex Shar for Mr. Roca.
And are you Mr. Roca?
Let's see.
Let me see what page you're on. All right, you entered a plea of guilty on June 20th. There was a request for a PSI and TAP evaluation. Have both parties received the PSI and the TAP evaluation?
Yes, Your Honor.
Yes,
Any
Judge.
Not
objections?
from State, Your Honor.
Judge, I don't have any objection to the TAP evaluation. I did want to be heard on the recommended conditions of deferred adjudication.
All right, according to your plea bargain agreement, there's $1,000 fine. State recommends deferred adjudication, and there's $60 to DPS. All right, counsel, do you have any witnesses?
I do not. Judge.
All right, state, any witnesses?
No, Your Honor, this is a case where State probably recommended deferred adjudication. The Honorable Judge Raymond Angelini was presiding, and since he did order the PSI, and so I don't have.
All right, anything you wish to say on behalf of your client, and state you may be excused.
Judge, the recommendations that were made by the officer on page 10 of the pre-sentence investigation report. Now, yes, this case started off as a DWI case. But it wasn't a drinking while it wasn't a driving while drinking intoxicated. When they stopped him, they found the marijuana in the car. He had admitted to smoking marijuana earlier in the day. They did testing, and they didn't test for alcohol, gave her breath samples, but they did test for Delta 9 THC,
Mhm.
and it came back above the level.
And if he's drug tested today, what are the results going to be?
He tells me he will be negative.
All right, he's going to get drug tested today, but continue.
Certainly. And so, you know, I understand that the state outside the plea agreement recommended that he have ignition interlock for half the term. Well, that device, you know, just tests for alcohol, ethanol, and not for, you know, for marijuana or cannabis. So I don't think he needs the ignition interlock, but more importantly, they're recommending that he cannot drive at all for their full term of supervision. And he is working. And in fact, I need to update the court.
Right, so I don't see where that says no driving. And no, that is a recommendation by probation. I thought you meant that was a recommendation from the state.
Well, just the ignition interlock was recommended in the plea agreement, well, outside the plea agreement, you know, at the bottom of that page. But the probation officer was recommending no driving for the full term of supervision. You know, he has, he's living with the mother of his children. They're together. He does have training as a barber, but within the last 3 weeks, he started working for Vivint, which is a home security company. He's a salesman for them. He works Monday through Saturday. And that's the type of job he's doing now. He needs to be able to drive. He needs to be able to, for work and to take care of his family. The mother of his children also works 50 hours a week. And so they're doing everything they can to live and take care of their young ones. And so really, I don't have any objections to the TAP evaluation. I would just ask the court to not impose the ignition interlock.
All right, let's do this. You say you're going to be negative? All right, so I'm going to have you go do a drug test and then we'll come back and I will make a decision on your application. Ms. Abrams, could you have him go do a drug test with Deanna? All right. Thank you. They'll let you know where you need to go. All right, Anthony Jamel Belk.
You should be on Zoom, Judge.
He's not on Zoom.
He's not on Zoom?
Yeah. All right, so they're going to call the county.
It's just most compliance hearing.
It's a
That's where I will rule.
pretrial services law. I think she might.
And also, have you received discovery from the state?
He was just recently
I was
appointed.
recently put on it, and absolutely. I think I don't know if the court wanted me here first compliance hearing or not.
No, I mean,
Or it's not
because he had
compliance hearing,
the
I'm sorry, it's
pre-trial.
bondage.
Yes.
Bondage. So yes, I do have the violation report then.
All right.
I have.
Just give us a moment.
Yes.
And so I haven't been able to see him because he's in Burnett County.
He,
They always flip for exempt.